Thank you. Thank you, Kurt. This is great. The question is whether the Civil Rights Act of 1866 rested on the Privileges or Immunities Clause or the Privileges or Immunities Clause, the Due Process Clause, or the Equal Protection Clause. Kurt points us to evidence in the debates about the Civil Rights Act suggesting that it was rested on the Due Process Clause of the Fifth Amendment and not on the rights of citizens, because in the 14th Amendment there's the rights of citizens provisions, the Privileges or Immunities Clause, there's the Due Process Clause, there's also the Equal Protection Clause. So what were people thinking about in debating the Civil Rights Act of 1866? And what were they thinking about when they talked, as they often did, about life, liberty, or property? Kurt uses the phrase due process rights. That's not one that was used during the Reconstruction debates. Life, liberty, and property a lot as summaries of civil rights, but due process rights not. It's easy to think that an invocation of life, liberty, or property is an allusion to the Due Process Clause of the Fifth Amendment. There wasn't a 14th Amendment yet then, but not necessarily. Indeed, the appearance of due process in the Fifth Amendment is something of an embarrassment to the claim that people have inalienable natural rights of life, liberty, and property, because the Due Process Clause says they can be deprived of life, liberty, and property as long as they get due process of law, suggesting that the life, liberty, and property it's talking about are very concrete rights, somebody's ownership of Blackacre that can't be taken from A and given to B without due process of law. But that's rather distinct from the general rules about civil rights that the Civil Rights Act was concerned with. So references to life, liberty, and property are not necessarily allusions to the Fifth Amendment, and invocations of the Fifth Amendment are not necessarily claims that only because of the Fifth Amendment do citizens or persons have rights of life, liberty, or property. Indeed, I wonder whether the people who are talking about inherent rights of life, liberty, and property really would have been prepared to say, oh, without the Fifth Amendment, they wouldn't be constitutionally protected. And indeed, at least one of the people Kurt talks about, Representative Lawrence, said, no, all these rights are anterior to laws and constitutions and don't need laws and constitutions. With that in mind, I want to talk a little bit about what some of the people said during the debates, starting with Lyman Trumbull, who introduced the Civil Rights Act in the Senate, who talked a great deal about the rights of citizens, talked about life, liberty, and property, did not specifically say that he was relying on the Fifth Amendment. So maybe I'm being partisan here, but I'm going to count Trumbull as endorsing the claim that the Civil Rights Act could rest on congressional protection of the rights of citizens, but not endorsing the claim that it rested on the Fifth Amendment. James Wilson, chairman of the House Judiciary Committee, introduced the bill in the House. Interesting set of speeches by Wilson. In a speech on March 8th, he rested the Civil Rights Act. This is sort of after they were trying to move on from the 13th Amendment, when doubts had been raised about resting it on the 13th Amendment. He rested it on the rights of citizens and specifically on the Privileges and Immunities Clause of Article 4. Adopting apparently an unorthodox reading of Article 4, but a number of times in that long speech talked about Article 4. Did not mention the Fifth Amendment. Then, when John Bingham, on I think it was the 8th of March, the 9th of March, Bingham said, what we need is power to enforce the Fifth Amendment. In the afternoon of that day, responding to Bingham, Wilson said, come on, prig. We already have power to enforce the Fifth Amendment. So he added an argument under the Due Process Clause to the argument he had already made about the rights of citizens. So it seems to me that he endorsed both positions. Yes, Congress can act with respect to the rights of citizens, and it can act specifically under the Fifth Amendment, which again, an invocation just of life, liberty, and property, is not necessarily a sign of. Similarly, Representative Lawrence, in a long speech, talked a great deal about rights of citizens and about Article 4, invoked the Fifth Amendment along with a number of other documents discussing life, liberty, and property, starting with a Declaration of Rights by the Continental Congress. I understand Lawrence to have been using the Fifth Amendment as evidence for the principle that American citizens have the right to life, liberty, and property, not as the source of that right. Again, he's the person who said these rights are anterior to any constitution. So Lawrence certainly can be read as endorsing the proposition about rights of citizens, not endorsing the proposition about the Due Process Clause of the Fifth Amendment. Kurt talks a little bit about Senator Cowan. I don't think Senator Cowan endorsed either of those propositions. He was having a colloquy with Senator Wilson. He certainly talked about the Fifth Amendment. Then later in that paragraph, he said, Well, now that there's the 13th Amendment and the slaves are free, they're emancipated, they are on the same legal footing as white people, and therefore they have protections in their life, liberty, and property, therefore they have the same remedies as white people. Seems to me that he was attributing the anti-discrimination rule to the 13th Amendment, saying once race discrimination is eliminated, they have everything, including the Fifth Amendment. I don't think he was thinking all that carefully. Representative Delano said the Civil Rights Act is unconstitutional. He wanted an amendment like Bingham's, but not identical to Bingham's, because he wanted Congress, here's a familiar principle, he wanted Congress to be able to act only in default of state failure to enforce rights of life, liberty, or property. Delano referred to life, liberty, property, and the pursuit of happiness, which is an important American principle, but the inclusion of the pursuit of happiness, like a lot of references to life, liberty, and property that are not in hoc verba the Fifth Amendment, life, liberty, and the protection of property, the acquisition of property, suggests that he wasn't thinking specifically about the Fifth Amendment. He was thinking about life, liberty, or property. Representative Thayer did endorse the Fifth Amendment view, reading of the reading of the Fifth Amendment that says that's the ground of the Civil Rights Act of 1866. Now, what about John Bingham? I want to say three things about Bingham. First, I have a lot more things to say about Bingham, but I'll make it just three. First, treating Bingham as the author of the second sentence of Section 1 is correct, but a little misleading. Those of you who have done some drafting may have had the following experience. You write a text designed to implement your plan. The rest of the group doesn't like your plan. You come up with new text designed maybe to slip your plan past them with the new text, or maybe to capture a compromise. Bingham's initial text was rejected in the House. Bingham came up with new text. So the fact that he was the person holding the pencil doesn't mean that they were implementing his plan. Rather, he may have been the person who was writing something for the rest of the Joint Committee. Second, how much credibility did Bingham have as a general matter? Well, Thaddeus Stevens, chairman of the Joint Committee on the part of the House, the person who introduced the 14th Amendment into the House, on behalf of the Joint Committee, about 6 months after all this, said the following to Bingham's face in a colloquy with Bingham. In all this contest about Reconstruction, I do not propose either to take his counsel, recognize his authority, or believe a word he says. The Speaker then said, the gentleman from Pennsylvania is not in order. So again, how much credibility Bingham had with other Republicans may be doubted. Third and most important, Bingham did indeed urge the claim that Congress, by enforcing the Fifth Amendment, if it had power to do so, could adopt the Civil Rights Act of 1866. He said, due process, life, liberty, and property, protects people, provides equality, and he didn't believe it. If you want to know whether somebody thinks that legal text A produces result X when that person wants result X, do not point him to an existing legal text that has A in it and ask him if it produces result X. He will say yes. Instead, hand him the pencil and say, draft something that will be a new authoritative text and see what you get. Bingham drafted equal protection of life, liberty, and property, did not draft due process. Eventually, due process came in. Two last points. One, Senator Stewart, in proposing what became sections 1977, 1978, 1981, 1982 in their Nomes to U.S. Code, explicitly distinguished between the rights of citizens and persons, and says the reason we have broken out the rights of real estate, the real estate related rights, which are now in section 1978, 1982, is because we are going to protect people who are not citizens, Chinese on the West Coast. He then, as Kurt quotes, talked a number of times about the constitutional provision on which that rested, and he said equal protection, equal protection, equal protection, 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 did not say due process. Very last point, how much confidence would the Republicans have had in the idea that a due process clause in the 14th Amendment would ban race discrimination? Almost all American states had due process clauses. Almost all American states had race discrimination. Did they really think that would work? Well, here's what we know about how much confidence the Republicans actually had in their unorthodox readings of the Constitution, or even their orthodox readings of the Constitution, because they needed the citizenship clause. they put the citizenship clause into the 14th Amendment, knowing that there was good authority for that proposition already, but they also knew they couldn't trust the courts. And so they nailed that down, and I think by making state citizenship a right of national citizenship, put in place one of the crucial moves that makes possible the equality-based reading of the Privileges or Immunities Clause, because they knew that they had to nail that down, and they did not trust the courts simply to adopt strange Republican theories about what the Constitution actually meant. I think the way they behaved with the citizenship clause suggests that they would not have taken the risk that courts, still to some extent staffed by Democrats, the people who had given them Dred Scott, were prepared to say, oh yes, it's been true all along that all those due process clauses make race discrimination unconstitutional. The Republican Party has a derisive nickname that it has often earned, but I don't think even Republicans were that stupid.
Kurt, you want to?
Yeah, a couple of things. This is what is so wonderful about originalism and how it leads us, right, to deeper understanding of the sources. I mean, we all have our different theories of privileges or immunities and equal protection, and we defend our theories strongly. And that forces us over and over again back to the historical record. And so I thank John for digging so deeply. I mean, that's wonderful. It'll force me to engage once again with all of those sources. Obviously, more than I can respond to is specifically, but actually not so much difficulty. Let me just say this by way of reply. This came up before. I think that Stephen Saxon made a similar point when I presented this paper earlier at another conference, that the invocation of life, liberty, and property aren't necessarily tied to a reference to the Fifth Amendment of due process. In these debates, I strongly disagree with that. They were singing lyrics, and it just would have been completely implausible for them to use the triptych life, liberty, and property without understanding that they would be heard as referencing due process and the Fifth Amendment. And in terms of, well, then we would expect someone at least to say Fifth Amendment due process rights. Well, yeah, here's James Wilson. What are the great civil rights to which the first section of the bill refers? I find in the Bill of Rights, which the gentleman desires to have enforced by an amendment to the Constitution, that, quote, no person shall be deprived of life, liberty, or property without due process of law. He continues, now I want to know whether these rights in the Civil Rights Bill are any greater than the rights which are included in the general term life, liberty, and property. So he links his terms life, liberty, and property to a specific quote of the Fifth Amendment Due Process Clause. Bingham says, the Constitution does not delegate to the United States the power to punish offenses against life, liberty, or property of the citizens in the United States, but leaves that as a reserved power of the states to be by them exercised. I am with Mr. Wilson in an earnest desire to have the Bill of Rights in your Constitution enforced everywhere. But I ask that it be enforced in accordance with the Constitution of my country. I actually think that my paper raises many references of specific instances where Fifth Amendment, due process, life, liberty, and property are tied together, so much so that I think the additional comments when they referred to the triptych, life, liberty, and property, clearly would have been understood. And even if they didn't mean them to be understood, and I think they did, the communicated meaning of those words would have been understood as a reference to the Fifth Amendment. Now, why would they do that? There were concerns at this time that they should not be messing with the Constitution. Anyone who has studied the debates over the 13th Amendment and the 14th Amendment would understand that they were very leery. They understood that there was a reverence of the Constitution that placed them at a disadvantage. It was an argument against amending the Constitution because we have no right to change the original deal. And so innovation was something to be avoided. Language that didn't refer, efforts that didn't tie themselves to specific provisions of the Constitution were viewed much more suspect than legislative efforts and amendment efforts which tied themselves to the specific language of the Constitution which had already been adopted in the original document. That made it very important for them to move along the lines that allowed them to point to specific constitutional provisions. So when they said life, liberty, and property, it would have placed them at a disadvantage to try to be speaking about some type of general theory of natural rights. What gave them a political advantage was to use the language of life, liberty, and and property in reference to a specific clause already in the Constitution. Then lots of other points, but in terms of Stewart's particular efforts and his reading of equal protection, again, the argument here is that equal protection was understood as an aspect of due process. References that these equal protection of due process rights existed prior to the Constitution. That's a very important part of my paper. That's one of the reasons why I think we have been wrong to link these rights to the special privileges of citizens. The whole effort of the first part of the paper is to explain that they understood these rights were natural rights that existed, that pre-existed the Constitution. These were natural rights that belong to all persons. It's one of the reasons why I think we've been looking in the wrong place. If you want to understand the Civil Rights Act, you have to understand their theory of the Civil Rights Act as not involving rights that only attach upon citizenship. These are rights that all people have, constitutionally or not, but that were specifically announced to be a part of the rights of citizens by way of the Due Process Clause. And then finally, I just have to do this in terms of the right to life, liberty, and happiness, and the pursuit of happiness. That was understood throughout antebellum literature as being a reference to the Fifth Amendment. The Fifth Amendment codified for the national Constitution the Declaration Statement of life, liberty, and the pursuit of happiness.